Hello, folks. It's 9 a.m. Thursday, November 5th, and this is the Colorado Oil and Gas Conservation Commission. This is a continuance of our mission change hearing. We are going to open it up today to closing presentations and then commissioner deliberation. Before we do that, let's see who we have with us today. Ms. Larson, if you could call the roll.
Of course. Commissioner Bogue. Commissioner Gonzalez.
Here.
Commissioner McGowan.
Here.
Commissioner Mesner.
Here.
Commissioner Mock.
Present.
Commissioner Najapa.
Here.
Commissioner Putnam.
Here.
Commissioner Robbins.
Here.
Mr. Chair, you have 7 out of 7 commissioners present.
Excellent. All right. Well, no time like the present. Let's get going. I believe that we had some initial comments from staff before we move into party closing presentations. If I could potentially call on Assistant Attorney General Minor. You're muted.
Thank you, Mr. Chair. I'm having one other technical difficulty, and then I will begin sharing my screen in response to the questions that the Commission presented to staff during the hearing on Tuesday about the number of Form 4 sundry notices that have been submitted and in some cases approved under current Rule 912. Staff have prepared the tables that I will present to you in just a moment that reflect those numbers, both in terms of where they are located and the years and months they were submitted. So I believe I should be able to share my screen now. All right. So on this screen, you should be able to see the submissions by month and year. You can see that they do come in we just did data for the past 3 years in a fairly mixed range. They come in throughout the year, and that is one of the reasons that staff did prefer the option of a sort of phased implementation schedule that would not concentrate on all of them at the same time. You can see there's somewhere around 250 to 300 a year. There was a sort of a jump in 2019 as a result of the Third Creek gathering line that was, we've heard a little bit about. Here they are arranged by county. You can see again that they are sort of varied in terms of where they're actually located. There are certainly concentrations in areas like Jackson County. There's a fair number in Weld, which really reflects the overall amount of development in Weld, not necessarily a concentration there. And I think the other thing that staff have provided on this slide is just that there are different reasons for the requests in different areas. In some places, they're more commonly submitted for purposes of braided head maintenance. Then there are also sort of a lack of access to infrastructure, which in some cases is older wells, in some cases it's sort of newer wells that haven't really developed that capacity yet. And I think that the variation in the reasons that the requests are submitted reflect why there is really some value in having staff with expertise in the region who've been sort of reviewing these over time, continuing to review them. And as you can see, most of these are fairly concentrated, though not entirely within the area that would be covered by the eastern region of the engineering division. So with that, I'm happy to answer any questions you might have. And I believe if Ms. Larson could also zoom in Ms. Byrne, she should also be able to answer any questions that there are about this data.
Thank you, Mr. Minor. Do we have questions for AAG Minor? Commissioner Messner.
Thank you, Mr. Chair. So that table indicates the submission date. What is there a year expiration date on those, or I can't remember what the timeline is for expiration after the submittal date.
AAG Minor.
Certainly, so Commissioner Mesner, there is a maximum of 1 year expiration date that runs from the date of approval. As you can see, there are often hundreds of the applications submitted at about the same time. So Ms. Byrne, as well as the other engineering supervisors, Craig Berger for the Western region and Diane McCoy for the Central region, they're not always able to get to them right away. So, but it is 1 month from, or sorry, 1 year from the date of approval is the maximum range. That doesn't mean that sometimes shorter durations are approved as appropriate on a case-by-case basis, which I think would be fairly likely for the ones that are submitted for Braden Head maintenance in particular. And that is the 1 year maximum is set by the 2016 notice to operators about current Rule 912. I don't know if Ms. Byrne has anything to add to that.
Ms. Byrne, did you want to add?
No, I think Joel's correctly characterized it. I think that usually the term limit that's given at the date of approval is less than a year because it's more from the submission date, because it's a rolling year application. So because of sometimes you get a slug of them, you can't get them all done in that exact time frame. So it's a year to keep it continuous. So that their actual approval time from the date, or the approved time period from the approval of the form may be less than a year to keep that rolling. So there's not a reward for us not getting done.
Thank you.
Commissioner Messner? Okay. Other questions? Well, thank you, staff, for that additional information. That is helpful to us as we listen in now to closing statements and then move into deliberations. With that, we have a list of closing statements. I'm just going to call it out in the order in which it was presented. The first party with a closing statement is Adams County, and they have 5 minutes. Give us a sec. We'll bring the Adams County folks to the room. Good morning, Ms. Fitch. Good morning, Mr. Dean.
Morning. I have a different setup this morning, so hopefully my screen share works as well. Greg is going to be taking most of this. I am just the moving the slides along. So let's get this started. All right, can everyone see my screen in presentation mode? Awesome.
We can.
Good morning, commissioners. As I said, this is the Adams County Mission Change Rulemaking response to the new 900 series, or response to the closing statements for 900 series rules. And Gregory Dean will take it from here.
Good morning, commissioners. This is Greg Dean, Oil and Gas Liaison for Adams County. County again appreciates all the tireless efforts of Director Murphy and her staff, as well as this commission in drafting and presenting a 900 rule series that is comprehensive, insightful, and reasonable. The county largely supports the November 3rd draft and only minor revisions to the following topics. Next slide, please. First, as it relates to allowable venting and flaring during production operations, pursuant to Rule 903D, the county supports proposed option 4 presented by staff for the submission of a Form 4 under the rule, requiring operators to submit all requests for venting and flaring to the director within 60 days of the effective date of these rules. The county does not support staff's preferred option, number 1, which would allow operators up to 1 year from the effective date to submit a Form 4 request. This extra year, combined with a 12 months of allowable venting and flaring from the date of approval of the request as proposed, would essentially give operators 2 more years of venting and flaring, plus the additional year that they've been granted since they were put on notice of the commission's intention to reduce such practices. The county understands the concerns regarding the use of COGC staff resources associated with processing these requests, but believes this commission is under a statutory obligation to ensure these rules protect public health, safety, welfare, the environment, and wildlife resources, and reduces the waste of natural gas. And allowing for this additional time is not sufficiently protective. Further, the county requests the commission adopt option A as presented and preferred by staff as the end date for permissible venting and flaring to be 12 months from the date of approval of the Form 4. We believe these requests would provide ample time for operators to prepare and submit all required information to the director for approval and further reduce waste and adverse impacts. We do see clarification, however, regarding the director's estimated time frame for the review and approval of Form 4s and whether venting and flaring would be allowed prior to such approvals. Next slide. Next, as it relates to cumulative impact studies, the county is supportive of the November 3rd draft of Rule 904, which can require operators to participate in studies evaluating all cumulative and climate impacts as conditions of approval of permits. Further, the county appreciates the added clarification by staff in the statement of basis and purpose that significantly expands on the Commission's intentions and scope of this rule. We believe the recent changes as issued provide the Commission with the needed flexibility to adapt this rule to site-specific and study-specific requirements, while also providing more regulatory certainty and clarification for stakeholders, that any required studies will be applicable to the application at hand and not some sort of de facto fee on operators, as alluded to by other parties in previous testimony. The county would, however, like to reiterate its request from our pleadings and previous testimony that the rule language should be modified such that any required studies, data collection, or study design under Rule 904 be conducted by third parties or external agencies in cooperation and coordination with operators, rather than be done by the operators directly to ensure any actual or perceived objectivity of the results. Next slide. And lastly, pertaining to spills and releases, the county restates its previous support for broad director authority to require any action necessary and reasonable to immediately report, investigate, and remediate adverse impacts associated with spills and releases in Rule 912. We further reconfirm our support of the enforceable implementation and reporting schedule for the remediation of spills and releases under 913, but reiterate its previous requests for local government consultation on the determination of such schedules prior to approval. The intention of this request is purely in the spirit of open communication and coordination between local governments and the COGCC as it pertains to impacts occurring within their jurisdiction. The county intends to leverage the Commission and staff's expertise in determining what remediation mechanisms may be necessary on a site-specific basis, whether that be installing monitoring wells, excavation depths, groundwater and soiling sampling regimes, etc. And this request for consultation notice would not reduce the authority of the director or the COGC for making those determinations. This request will ensure remediation timelines between local governments and the COGC do not conflict, nor become overly burdensome or duplicative. This will further ensure local governments can continually enforce all applicable local regulations associated with remediation and excavation projects within their boundaries. This concludes our testimony and closing on the 900 series. Thank you again for your valued time and consideration of the county's request.
Thank you, Mr. Dean. Thank you, Ms. Fitch. Do commissioners have questions? All right, I'm not seeing questions. Thank you for your tailored testimony. It's always helpful. We appreciate it, and I'm sure we will think through the issues this afternoon as you have presented them. We now will turn to Anthem Ranch, who also has been allocated 5 minutes.
Good morning.
Morning.
Chair Robbins, commissioners, and staff. It's been a long road to get to this point. Your usual reliance on verifiable scientific data and coordination with CDPHE and AQCC has been critical in decision making. Where we are today is a paradigm shift from the old COGCC, and I'm grateful for that. Are we where Anthem Ranch Community Association's Board of Directors would like to be? With respect to some rules, yes, and with respect to others, not quite there. However, we are most appreciative of what we consider to be positive changes. I'm going back before even the 900 rules, the setback requirements now for 2000, the reduction in time allowed for flaring and venting in the 903 rules, all will help protect the health, safety, and welfare of all of us in our environment. Moving forward, however, the proof will be in how you and the staff administer and enforce these rules. We urge you to be vigilant in applying the adopted regulations and protect the health, safety, and welfare of all Coloradans and our beautiful environment as established by Senate Bill 19-181. Be judicious. No, actually be miserly with respect to allowing variances. Industry must prove and provide compelling data to allow for you to grant any variances. We'll be watching and counting on you to fulfill your charges. Thank you so much.
Thank you, Dr. Spees. Appreciate your coming before us again. Do commissioners have questions? I don't see any questions. And from your testimony, I didn't hear a specific sort of testimony or red line edit other than, where we are now. Am I right on that?
That is correct.
Just sort of how
You've
how
moved
we
pretty
implement.
much on 903 in the direction that we'd like to see. Still have some concerns about 903D with the wells that are already in place having 12 months to get pipelines and whatnot in place to avoid flaring. But in the rest of them, we feel that you've moved in the direction we have asked.
Great. Thank you very much. We
Thank you.
Continue to appreciate your work with us. We will now move to the citizen groups. Give us a second to get the appropriate individuals on board. See Mr. Freeman. Are you flying solo today, Mike, or do you have?
No, good morning. I think Tom Delahanty should be on as well.
All right, I think we just found him.
Good morning.
Good morning, Mr. Delahanty.
Thank you, Commissioners. Tom Delahanty on behalf of the citizen groups. Our closing comments will address flaring and pits. Before launching into the substance of the 900 series rules, I want to quickly address a procedural issue. Last week, we presented a table showing that most produced water across the state of Colorado is unsuitable for beneficial use, and WRLG incorrectly asserted that this table was only for the Wattenberg field, seemingly based on the study's title. We then moved to include that study in the record to show that the table was, in fact, for the entire state. And Hearing Officer Thomas deferred our motion to the Commission and directed us to raise it here. So we're requesting again that the study be included in the record. Moving on to the substance of the rules, we'd first like to thank the Commission and COGC staff for their excellent work on the 903 flaring rules. As we noted last week, we strongly support the prohibition of routine venting and flaring. We also appreciate staff's new language in the statement of basis and purpose that addresses our concern about flaring that results from inadequate separation prior to tanks. We urge the Commission to adopt Rule 903 and the associated SBP language. We also appreciate and support the latest changes to Rule 904. We'd next like to thank the Commission and staff for the additional refinements to Rule 903D6 on pit emissions. Staff's latest draft language, which sets emissions limits based on proximity to building units, the pit's location within an ozone non-attainment county, and whether the pit is used for recycling, is a good approach. That said, we believe there are still several areas for improvement on the PIT's rules, many of which can be addressed through staff's proposal for a working group on PITs. First, we ask that the scope of the proposed working group be broadened to address not just emissions, but also some of the other issues that have come up in this rulemaking around PITs. The evidence has indicated that there are significant information gaps about what's occurring on many existing PITs, primarily due to inadequate records, the quality of produced water in those pits, and the threats that those pits pose to groundwater and wildlife. And several times you, the commissioners, have asked about the number of pits in Colorado, the current emissions levels of those pits, and how they're maintained and their fluid contents. And we think these concerns are just as significant as emissions are, and we believe they could be addressed in the working group as well. That relates to the next issue, which is that the draft rules would delay for 18 months the submission of data that's needed for the working group to be effective. The produced water information required under Rule 909J and the associated emissions data under Rule 903D6C would not be due until July 15th, 2022. But according to the SBP, the PITS working group is supposed to report back to the commission by January 15th, 2022, 6 months before these test results are due. We think it's totally feasible for operators to submit that testing sooner, and getting it earlier will be helpful both for staff and for the working group to address the numerous concerns around PITS. The third issue for the working group to address is Rule 903D6B, which establishes when existing PITS can be exempted from the new emissions limits. We believe the draft language is vague and overly broad, and the working group can address this problem by honing a more careful and more protective set of standards based on the high quality data that comes in. Our final request is on Rule 909G, which provides exemptions for multi-well pits in several counties in the Raton Basin and eastern Colorado that were constructed before certain dates. To be clear, these are unlined pits that will be operating indefinitely without complying with new standards for centralized E&P facilities, and we don't think that such a blanket unlimited exemption is appropriate. The unlined multi-well pits identified in Rule 909G should be subject to the same standards as other pits, and this is another issue that the working group could address. That concludes our remarks, and once again, we thank you and the staff for all of your continued hard work on these complicated and important rules.
So, Mr. Delahanty, you mentioned the working group should be focused on 3 or 4 different items. Did you have a suggestion on what the rules should look like while the working group is working?
I guess one possibility for change would be the timeline for the produced water and emissions sampling. So I think that if that deadline were moved up, then that would be really helpful for the working group. And I think the other place that maybe changes could be made are actually just in the statement of basis and purpose to explain what that working group would be looking at, and just being explicit that it could include some of these other issues, including things like fencing and netting, for example.
Okay. Commissioners, questions for the citizen group representatives?
Mr. Chair.
AAG Davenport, I'm sorry, I didn't see you. Hello.
No problem. Thank you. I would like to alert the commission to the very first matter that Mr. Delahanty referenced, which is the inclusion in the record of a study. If the commissioners recall, Hearing Officer Thomas issued an order on that and did reference that WRLG objected to including that study in the record. I would recommend to the commission that you do make some affirmative statement about whether or not that study is in the record or not. The hearing officer deferred that decision to you. And so I think it's your option if you want to hear from WRLG on their objection, if you're sufficiently informed as to, after seeing the order, what you'd like to do in that regard. Just wanted to raise it because the commission had not made an affirmative statement about whether or not that was in the record or not.
Thank you, Mr. Davenport. This study, I thought that you had provided it to us, Mr. Freeman. Is that correct?
That is correct, Commissioner Robbins. We submitted a summary of it in our rebuttal statements last week in an effort to respond to some of the points that industry parties had made. And then we followed up by submitting it that evening along with to the commission and the hearing officer as well. So it has, the study itself has been submitted to the commission, we are just following up on the hearing officer's recommendation that we ask for confirmation that it is in fact part of the record for these proceedings.
Okay. In AAG Davenport, the reason that we would act on this is because it came in late, like it came in that evening after we were done that day. And then there's been an objection now from another party as to whether the study should be a part of the record. I guess my question is it issue of whether it's part of the record, or is it an issue of what's within the study? And like because I think that the two parties disagree about what the study says. And I personally don't have a problem with it being in the record. And I think we're all smart enough to be able to make our own determination about what it says and what it doesn't say.
Thank you, Mr. Chair. I think the main issue for you is whether or not the study is included in the record. Not necessarily this. The parties are making substantive arguments about what that study says and means, which they can obviously make. I'll just reference the hearing officer's order to you, which says that WRLG argued that the inclusion of the study in the record is improper because it was offered after party presentation time has been used, and no additional time or supplemental filings are contemplated in the case management order. Mr. Friedman, Mr. Delahunty may disagree with that. I'm just reading the hearing officer's order in that regard in reference to the issue that whether or not that study is included in the record.
All right. Well, why don't we do this? If any commissioners have questions about the study to the citizen groups, now's the time to ask that question. And then perhaps we would wait to hear from WRLG, and then we can take up whether the study's in the record as kind of our first order of business under deliberations. Is everybody okay with that? Okay, I'm seeing nodding of heads. So any further questions for the panel on the study or with regard to their closing? All right, I'm not seeing further questions. Thank you both for appearing before us and for your presentation today and throughout our rulemaking. We will now move to our next panel, which is Citizens for a Healthy Community.
Thank you.
Likewise, we'll have 5 minutes.
Morning, commissioners. Can you hear me?
We can hear you.
Wonderful. Natasha Leger, Executive Director, Citizens for a Healthy Community. My remarks this morning will be brief since we generally support the revised rules. We appreciate the direction to staff in the statement of basis and purpose regarding transparency and automatic notice of spills and releases to those who opt in to receive such notice. We recognize that staff is under tremendous pressure and limited resources to accomplish the goals set out in 181. In staff's presentation, Director Murphy mentioned concerns over the volume of information that the public may unintentionally be signing up for because staff receives notice of 1 to 2 spills a day, and that staff seeks to manage the overwhelming information. We appreciate the thought behind this, as all of our inboxes are overflowing with information, and often information we did not request. However, in this instance, the public has requested opt-in notification, not for the COGCC to be a gatekeeper to that information. If the public finds that the information is too much, it can always opt back out. We would prefer that staff put its energy and resources into developing a targeted GIS-based automatic opt-in notification system that would, by its targeted nature, reduce the volume of information going to each individual. If exploring a targeted GIS-based notification was the intent of the comment, we agree. If the intent of the comment was to prolong the automatic notification of general information, then we urge the Commission to clarify in the statement of basis and purpose the steps that staff plans to follow to ensure that the public receives the information requested, which first starts with enabling opt-in notification of spills and releases reported to the Commission, then to explore options for more targeted automatic notification. Lastly, regarding the thornier issues of pits and emissions, we did not comment specifically on this issue in our presentations as we supported the position of citizens groups. However, with Commission's direction and staff's revision, carving out an exception for Western Slope, we feel compelled to comment. We recognize the difficult decision in front of you. The Western Slope is a climate hotspot, warming faster than the global average, and as a result, we are experiencing continued water stress. However, trading emissions for water recycling, which is increasingly necessary because of climate change, when the industry is the largest contributor only perpetuates the inevitable. 1261 also stated that we should not be trading good air in one part of the state for bad air in another part of the state. Just because the West Slope is not a non-attainment zone doesn't mean that we should continue to allow emissions that will eventually get us there. Particularly concerning were comments from WRLJ and industry stating that some operators are emitting 2 tons per week, which is north of 100 tons per year of VOCs. If operators cannot economically operate in a manner that protects our climate, which directly impacts public health, safety, welfare, the environment, and wildlife, then they should not be operating on the Western Slope. Thank you again for your consideration and hard work on this series. We look forward to continued cooperation with staff in working towards an opt-in email notification for spills and releases. Thank you.
Thank you for your closing today. Commissioners, do we have questions for Ms. Legere? All right, I'm not seeing any questions. Thank you again for your continued participation with us.
Thank you.
At this time, we would turn to are we at Colorado Communities for, no, Colorado Rising, Ms. Larson?
Mr. Chair, we're not able to find Mr. Salzar in the meeting, so we'll keep looking for him and we can move on to Communities for Climate Action.
Very good. We'll put a check mark beside Colorado Rising in case Mr. Salzar shows back up, and we'll go to Colorado Communities for Climate Action. Ms. Keene, we've made you a panelist. You would want to unmute yourself.
And Mr. Chair, if Ms. Keene isn't ready to present, we can put her back into the meeting and check in with her, and then we could move on to, let's see, Wild Earth Guardians and Colorado Environmental Advocates. Oh, you know what? It looks like Ms. Judkins, excuse me, is going to be presenting on behalf of CC4CA. So we'll move Ms. Judkins in. So just a moment.
Good morning, Commissioners. Can you hear me?
We can.
Great, thank you. My name is Sarah Judkins with Kaplan Kirsch and Rockwell, representing Colorado Communities for Climate Action. CC4CA thanks the staff, commission, parties, and public for their hard work on this rulemaking and appreciates the opportunity to comment on staff's final draft rules. CC4CA generally supports the latest draft rules, but believes they can be improved in several aspects. Colorado communities are already experiencing significant environmental, health, and economic consequences of climate change, and reducing emissions from the oil and gas sector is a critical step to reducing Colorado's contributions to climate change. The impacts of climate change are often felt most immediately and intensely at the local level, and local governments are often the first responders to climate-intensified disasters, including floods and wildfires, as we have seen this summer and fall during this year's devastating wildfires, including the 3 new significant wildfires in northern Colorado during the month of October. CC4CA supports the new clarifying statement at the beginning of Rule 903 that venting and flaring constitute waste and are prohibited except as allowed in Rule 903. The statement importantly sets forth the Commission's expectation that venting and flaring should not be permitted or undertaken except pursuant to a specific exception under the rules. CC4CA supports the similar changes to language in the Statement of Basis and Purpose that states it is the Commission's intent to prohibit venting and flaring and require capture in all circumstances, but where Rule 903 permits an operator to not capture gas, the Commission intends for the operator to flare rather than vent unless specifically permitted by Rule 903. For venting and flaring from existing wells under Rule 903 D3, CC4CA believes that the longest duration for which an operator should be permitted to request an exception on the prohibition on venting and flaring is 6 months. Regardless, every effort should be made to minimize this duration so as to reduce greenhouse gas emissions from venting and flaring as quickly and effectively as possible. Moreover, to support the quickest phase out of venting and flaring, CC4CA supports the option presented by staff that the latest submission date for such a request should be January 15th, 2021, the effective date of the 900 series rules. This would, under the current 12-month duration, lead to the expiration of the permissions to vent or flare granted under Rule 903D3 sometime in early 2022 at the latest, rather than some later date in 2022 or early 2023, under staff's other proposed options. In addition, CC4CA believes that the end date for all permissible venting and flaring under Rule 903D3 should be January 15th, 2022. Again, this will ensure that permissible venting and flaring at existing wells under Rule 903D3 is phased out more quickly. CC4CA supports the requirements for local government notification for planned and unplanned flaring in Rule 903A, but believes that these notifications should also cover venting as proposed in staff's June 19th draft of the 900 series rules. Providing these notices will help ensure that there is transparency around venting events. CC4CA does appreciate the new language in the Statement of Basis and Purpose, which states the Commission intends for the Form 42 Notice of Well Liquids Unloading to be sent to the relevant local governments to ensure that local governments receive real-time notice of high emissions events. Requiring broad notice to local governments will help ensure transparency around these events. CC4CA understands that some local governments may not be interested in receiving these notifications, but they can always opt out under Rule 903A3. Turning to Rule 904, CC4CA supports staff's improvements in this new draft. CC4CA appreciates the specific incorporation into the annual director's report of the status of the greenhouse gas reduction roadmap and the role of oil and gas operations in achieving reduction targets for the sector. In addition, CC4CA supports the requirement that the report include data gathered in the CIDR database regarding both anticipated and existing impacts from oil and gas operations. CC4CA also supports the addition of Rule 904C, which would permit the Commission to establish informational dockets to gather information to evaluate specific cumulative impacts from oil and gas development. CC4CA encourages the Commission to use this process to continue to evaluate and understand cumulative greenhouse gas emissions from oil and gas operations and ways to reduce such emissions. CC4CA also supports the additions to the Director's report of information relating to evolving or new innovative technologies or measures to reduce emissions, reports from government agencies or academic institutions related to protecting public health, safety, welfare, the environment, and wildlife resources, and other information requested by the Commission. CC4CA appreciates the opportunity to participate in this rulemaking and thanks the Commission and staff for their time, dedication, and careful attention to these important issues. Thank you.
Thank you, Ms. Judkins, for your closing. Do commissioners have questions? Commissioner Najapa.
Thank you, Mr. Chair, and thank you, Ms. Judkins. I appreciate your comments. I may have missed this, so apologies if I just didn't catch it, but with respect to the venting and flaring edits, I heard you say that you were looking for option B with the expiration of all venting by January 15th. What about in those instances when a gathering line is lost? Are you comfortable with the 12-month period in those instances?
Yes, CC4CA supports those very limited exceptions and circumstances where there may be loss of gathering line or kind of an exceptional event like that, with the way the staff has proposed it in the draft rule. Thank you.
Other questions from commissioners? Seeing none, thank you, Ms. Judkins, again for your presentation and your group's participation with us. Ms. Larson will now move to Colorado Environmental Advocates and Wild Earth Guardians.
That is correct.
Good morning.
Good morning.
I guess I'll just begin here. Thank you again for the opportunity to present. My name is Catherine Merlin on behalf of Wild Earth Guardians and Colorado Environmental Advocates. I'll just read for you the comments that I have for this morning. My first comment is about norm contaminated waste. I discussed this issue quite heavily in my presentation, but it didn't really seem to stick with the commission. I didn't hear discussion about this issue. I apologize if I just missed it, but not having heard that discussion, I'm unclear as to why this issue didn't seem to get a lot of attention. E&P waste can be heavily contaminated with a variety of radionuclides, and this commission should ensure that they're adequately identified and safely disposed of. Understanding that CDPHE is currently engaged in rulemaking on the issue of T-norms, there are not currently sufficient rules in place. And so we just appreciate bringing your attention back to that issue somewhat. Secondly, I was asked a question, I believe by Commissioner Putnam during my presentation regarding raising penalties for unauthorized releases to deter conduct that can be difficult to detect. While the statute does limit the penalties that can be imposed, they are limited on a per violation basis. There are violations mentioned in the statute that don't appear in the rules. So the 900 series is a place where failure to report unauthorized releases would be included as a violation. There are numerous reporting requirements in the 900 series, primarily in Rule 912B. However, I couldn't locate a rule that required operators to report unauthorized releases generally. And also, although the statute mentions penalties for aiding and abetting violations, I don't believe that that has been incorporated into the rules. Thirdly, our groups generally support the direction that the rules have taken with regard to venting and flaring. We believe some additional tightening is warranted. We're still concerned that the rules don't provide sufficient sideboards to limit venting during maintenance and repair under Rule 903D1B. On Rule 903D3, we're still concerned that this is effectively grandfathering in existing wells and giving them a pass to keep venting and flaring. They provide alternative language around bringing existing wells into the fold of regulation. Our preference is sooner rather than later. So option 2, in terms of a new Form 4 gas capture plan submission by January 15th, 2021. And option B, in terms of the duration of any one-time Form 4 approval. So only until January 15th of 2022. This concludes our remarks this morning, since this is our last opportunity to speak with you on this rulemaking. We want to again just sincerely thank you for what's obviously a lot of thoughtfulness and hard work that's gone into this. And we wish you luck with the rest of your deliberations and look forward to seeing the final version of the rules that you adopt. Thank you so much.
Thank you, Ms. Merlin. I have to confess, I had technical difficulties and got booted out of my own meeting for a portion of your closing, but I'll go back and listen to it. So I apologize for that. Not sure what happened. Are there questions from other commissioners to Ms. Merlin? Not seeing questions. Thank you for your participation with us. It has been helpful to us as we've worked through the issues, and we look forward to continuing to hear from you and your clients at the commission.
Thank you very much.
All right. We'll now move to Earth Guardians and Our Children's Trust, I believe.
Good morning, commissioners. Nathan Bellinger. Hi. Nathan Bellinger on behalf of Earth Guardians and Our Children's Trust. I'd just like to note that Maya Kane is also listening in today, co-counsel, but she won't be presenting, so I don't think there's any reason to join her as a panelist right now, but she is in the Zoom meeting as well. I'd like to begin by thanking the COGCC staff, the commissioners, and all the parties for their hard work and long hours over the course of this rulemaking process. I think everyone's hard work is really a testament to the import of these rules. We'd like to offer our support for Rule 904, the revised version, as we believe it'll help the Commission provide it with information to better evaluate greenhouse gas emissions associated with the oil and gas activities that it permits. That said, we continue to believe that the rules do not fulfill the Commission's obligation to address cumulative impacts from Colorado's oil and gas development and protect Coloradans' health, safety, welfare, environment, and wildlife resources from those cumulative impacts, which include the ongoing climate crisis. In our written filings, expert testimony, and public presentation, we have presented the Commission with evidence that in order for Colorado to meet its greenhouse gas reduction targets which are necessary to protect public health and the environment, a significant reduction in greenhouse gas emissions is necessary in the next 5 to 10 years, with additional reductions thereafter. However, it is still not clear how the Commission will ensure that greenhouse gas emissions from the oil and gas sector will decline to levels consistent with the greenhouse gas emission reductions required from the oil and gas sector. Now, of course, the Commission is not alone in regulating emissions from the oil and gas sector, and it should continue to coordinate with CDPHE to reduce emissions from ongoing oil and gas development. But the Commission cannot rely entirely on other agencies to ensure that the greenhouse gas sector meets its sector-specific greenhouse gas reduction targets. As the only state agency responsible for permitting the production and development of oil and gas resources, only the Commission can promulgate the necessary statewide rules to ensure that oil and gas production declines in the coming years, so as to ensure that the greenhouse gas reduction targets for the oil and gas sector are met. There is substantial evidence in the record now to support the adoption of a rule that would require a 25% reduction in oil and gas production over the course of the next 10 years, in addition to the rules that reduce emissions from ongoing oil and gas development. Despite our best efforts to have the Commission consider such a rule, there's been no deliberation or conversation about reducing oil and gas production. And therefore, at minimum, we would appreciate it if the commissioners or staff would explain on the record why they are declining to adopt a rule that commits to a reduction in production and sets numeric greenhouse gas reduction targets for the oil and gas sector. In the last couple of days, I've received comments on the current rules from Colorado youth that were either petitioners on the OCT petition or are members of Earth Guardians, and I wanted to share some of their words with you. Annabelle B. says, "I am in mourning. A refusal to commit to addressing the climate crisis and a refusal to commit to reducing Colorado's oil and gas development puts an expiration date on my future, as well as those futures of those who come after me." Arian A. said, "Human life must be prioritized over economic benefit because no planet means no future." Julia W. said, "All I have ever dreamed of is to give my future family the same amazing life that I had growing up here in the Rocky Mountains. Yet every day the COGCC fails to take action, that possibility becomes slimmer. The future I envisioned did not involve air quality so bad I had to carry an inhaler in my back pocket, scorched mountainsides, or dead forest as far as the eye could see." Marlo B. said, "We're no longer asking the COGCC to commit to addressing the climate crisis and reduce oil and gas development to protect our future. We are asking the COGCC to protect our state now." In conclusion, Colorado's historic and ongoing oil and gas development is inconsistent with the mandates of the Oil and Gas Conservation Act and the protections guaranteed by Colorado's Constitution. So in order to bring the Commission's rules and conduct into compliance and prevent further infringement of these youth rights, the Commission must do its part to protect Coloradans, and especially its youth, from additional climate disruptions by significantly reducing greenhouse gas emissions from the oil and gas industry in the coming years. Thank you for your time.
Thank you, Mr. Bellinger, and thank you for your closing statement. Do we have questions from commissioners? All right, I'm not seeing questions at this time. Thank you for your continued participation with us.
Thank you.
We will now, I believe, go to Noble Energy, Occidental Petroleum, and PDC Energy for a 7.5-minute allocated presentation.
That is correct, Mr. Chair. The party presenter, Mr. Neslin, has a conflict later today, so we'll be calling him now.
Very good.
Good morning, commissioners. Can you hear me?
Yes.
Okay, very well. Good morning. Dave Neslin speaking on behalf of Noble, Occidental, and PDC. I'm going to be very brief this morning. First, we want to thank Director Murphy and the COGCC and CDPHE staffs for all of their efforts and good work on the 900 series rules and the statement of basis and purpose as reflected in the November 3rd drafts. Second, we accept the draft rules in their current form, have no further comment at this time. Thank you.
Thank you, Mr. Neslin. Do commissioners have questions? Commissioner Nanjapa.
Thank you very much, Mr. Chair, and thank you, Mr. Neslin, for the comments. Great to hear that you're in support of everything. I was just curious because some of the draft rules include options. Does that mean that you're also supportive of either option?
Commissioner Nanjapa, thank you for the question. The rules that involve options involve operations that the three companies do not participate in. So they don't use pits. And so we don't have a dog in that fight. That's not to take away from positions that other industry parties may have, but we do not have a position with respect to those options. Thank you.
Thank you.
Other questions? All right. Thank you, Mr. Neslin. Thank you for your
Commissioners.
Continued participation with us. Ms. Larson, will we now move to Conservation Colorado, et cetera, et al.?
Mr. Chair, excuse me, we're still not able to find Mr. Sura in the meeting, but we do have a hand raised. So one moment, let's bring in the participant who's raising their hand. That may be Mr. Sura. Mr. Sura, are you in the meeting?
I am. Thank you.
And Mr. Sura, before you get going, Ms. Larson, yep, I was going to say, let's remove Mr. Neslin from the panel so that he can go do his other thing. Hello, Mr. Sura. We have you now. I believe you've been allocated 5 minutes.
Thank you. I'm going to share my screen. Want to make sure you see that?
We do.
Great. Then I'll begin if that's all right.
Yep.
Thank you. Good morning, commissioners. Matt Sura, representing Conservation Colorado and allied organizations. We support the changes recommended by you all and carried out by the COGC staff. We believe that the 900 series rules will help the Colorado Oil and Gas Conservation Commission meet its mandate to protect public health, safety, welfare, and the environment. We support the changes proposed to Rule 903 that state unequivocally that routine flaring and venting of natural gas is prohibited in the state of Colorado. Flaring is a waste of natural resources and is a practice that we can no longer afford if we are to meet the challenge of climate change and the mandates under Senate Bill 1261. We particularly want to voice our appreciation for the industry parties such as Dave Neslin that you just heard from that supported these changes. Rule 904 also demonstrated some thoughtful deliberation by this commission and excellent work by the COGC staff. We heard Director Murphy's concerns that this meant additional work for staff and agree that the ongoing evaluation of cumulative effects of the oil and gas industry will represent significant new work. Over the past several months, we and other parties brought you several experts from the University of Colorado, the CU School of Public Health, who are leading researchers investigating air emission impacts and water quality concerns and conducting health studies. In the next few weeks, we will also bring you other national experts on wildlife issues. Colorado is extremely fortunate to have leading universities such as the University of Colorado, Colorado State with its METEC facility that is specifically investigating how to detect gas leaks from the oil and gas equipment, and the School of Mines, one of the leading engineering universities, and federal institutions such as NOAA, the National Oceanic and Atmospheric Administration. I encourage the staff and this commission to reach out to these leading researchers and institutions and partner with them in the work of evaluating and addressing cumulative effects of the oil and gas industry. I'll personally like to offer my assistance in making that happen. In 905, management of E&P waste, Colorado Oil and Gas Conservation Commission and Colorado's oil and gas industry is a leader in many respects, but is not leading on the issue of reusing and recycling water. As I stated last week, Pennsylvania offers a blueprint for Colorado because its regulations prioritize reusing flowback and produced water by requiring operators to submit a wastewater source reduction strategy. In 2017, 52% of flowback and produced water from Pennsylvania wells was reused at well pads for oil and gas operations. Water plans that are part of an oil and gas development plan in the 300 series require operators to state why they are not going to or don't intend to use reused water. The 900 series has to address the other side of that coin, requiring operators to at least consider recycling options rather than disposing of water in an injection well. In the discussion last week, the staff stated that draft regulations were intended to allow an operator to change its operations through a Form Sundry notice to allow recycling. Our proposed changes, you can see here, would require the operator to at least consider recycling options upfront as part of its waste management plan. Finally, we support the comments you've already heard from the citizen groups on the issue of pits. We believe that the changes are a good first step, but more needs to be learned through the working group process. We're particularly interested to know where the existing pits are located, since the status of many of the pits in the Colorado Oil and Gas Conservation Commission map, as seen here, are largely unknown. We hope that the staff would take more samples of the water from pits to have a better idea of the threat it poses to wildlife and groundwater, as well as taking samples of the inflow to better understand the potential for pits to contribute to air quality concerns. We agree that the working group effort outlined in the statement of basis and purpose should be expanded to also consider netting and fencing requirements. Thank you again for your thoughtful work on the 900 series. That concludes my statement.
Thank you, Mr. Sura. Do we have questions from commissioners? Okay. Thank you, Mr. Sura. We appreciate your client's continued participation with us. At this time, Ms. Larson, are any of the folks that were not available, did they ever make themselves available? And if not, are we ready to go to the industry group at this time?
At this point, we are ready to move on to industry. We've not been able to find Mr. Joe Salzar, Phil Doe. I believe those were the only two groups that we've not been able to locate this morning.
All right, then.
So we will start bringing in the industry panel. Give us
Okay.
just a moment.
And Ms. Larson, can you confirm that you have all 4 of our speakers, myself, Mark Matthews, Jim Martin, and Kelsey Wazelinski? I just don't see them all.
Give us a moment. We are still populating the
Thank you.
Zoom. Mr. Colclasure, you should have everyone in the meeting now.
Thank you very much. And thank you for putting up the slide. We're just going to leave it on this cover slide for the first minute or so. Good morning, commissioners. KOGA and the industry group sincerely appreciate the hard work of staff and all participants in this rulemaking to get to this point. The collaborative process has improved the proposed rule, and we appreciate that, but the industry group has some remaining concerns to raise, starting with venting and flaring. The industry group accepts the proposed definitions of venting and flaring with the caveat of the Commission's directive that additional guidance is required to clarify the definitions of these terms. We ask staff to prioritize this document and prepare it as soon as possible with input from affected entities. Operators need certainty regarding what constitutes venting or flaring and need to understand their compliance obligations before the rules take effect in just 2 short months in order to begin planning. Language was added to the introduction of Rule 903 and the Statement of Basis and Purpose, saying that venting and flaring represent waste and pose safety and environmental risks. These statements are not accurate in all situations. Venting or flaring is legally not waste where it is necessary to produce oil and gas, and natural gas is sometimes vented or flared to enhance safety and mitigate a dangerous situation. And the main purpose of flaring is to reduce environmental impacts and risks by avoiding venting. To avoid misstating the law or the facts, we encourage the Commission to delete the new preface to Rule 903 and rely on the virtually identical language in the Statement of Basis and Purpose where it is presented in context with a broader explanation of venting and flaring. Further, this broad prohibition on venting and flaring should not be interpreted to undermine the carefully crafted positions or provisions in the drilling and completion sections of Rule 903 on when venting and flaring can or cannot occur. Next slide, please. The corresponding language in the Statement of Basis and Purpose also needs one revision. The current draft says that where Rule 903 allows an operator not to capture natural gas, the Commission intends for operators to flare rather than vent, unless venting is specifically allowed. But this language is problematic because gas must be captured before it can be combusted. Flaring gas without capturing it is impossible. This appears to be an inadvertent wording, and we recommend the following change to clarify the language so that you substitute the word capture with the words sell or beneficially use natural gas. Next slide, please. We seek a technical correction to the Statement of Basis and Purpose language, which says that in its definition of flaring, the Commission does intend to exclude combustion that is required by the AQCC for purposes of emissions from tanks. A correction is needed because the AQCC does not require operators to combust emission from tanks, only to control emissions. Combustion is an option, but not the only option, and so we suggest changing the language as shown on the screen to say the Commission does intend to exclude combustion pursuant to AQCC requirements to control emissions from tanks. Next slide, please. The industry group also seeks clarification of the Statement of Basis and Purpose language that requires operators to use current effective technology to capture natural gas drilling during all phases of oil and gas operations. This statement should be explained in the forthcoming guidance. And now turning to the slide, proposed Rule 903 D1B allows venting during maintenance and repair activity. Venting may be necessary during maintenance, but flaring, where possible, would reduce emissions. However, the current draft appears to allow only venting and not flaring. So we propose the red line shown on the screen to allow gas to be vented or flared during maintenance activities. Next slide, please. In the same section of Rule 903D1, outlining the exceptions where venting or flaring is allowed, Rule 903D1E allows venting or flaring during well liquids unloading. You can have similar emissions during plugging events. Both of these activities are covered by AQCC Regulation 7, so we propose a technical correction to allow venting or flaring during well liquids unloading or well plugging, as shown on the screen. And with that, I will turn it over to Jim Martin from API.
Good morning, Chair Robbins, Commissioners. Jim Martin for API Colorado. Can you hear or see me? Yes, great. Sorry, one of my screens just went dead a moment ago, so heaven only knows what's going on with my system here, but I will be brief, not quite as brief as Mr. Neslin, but brief nonetheless. As you just heard from Mr. Colclaser, there remain some definitional and implementation issues that revolve around the terms venting and flaring. However, API Colorado also recognizes the hard staff work that's gone into this issue. While API Colorado has substantial concerns about this issue, we're prepared to work with the staff to develop clear guidance around this issue. Moreover, we think the development of guidance on this issue should be a top priority for staff, since Rule 903 is central to drilling, completions, and production, as well as prevention of waste. Finally, API Colorado also continues to have real questions about the derivation and utility of values in Table 915-1. Again, we hope these issues can be narrowed in guidance, and we look forward to working with the staff on those issues. We also believe this issue should be a top priority for guidance, and thank you very much for the opportunity to speak with you today. I think I'm going to turn it over to Kelsey Wazelinski.
Thank you, Jim. Good morning. Kelsey Wazelinski with Jost Energy Law. We represent Crestone Peak, Great Western, High Point, and Mallard for the 900 series rulemaking. We appreciate staff's proposal to shorten the reporting time for well liquids unloading events in Rule 903D1E. Unfortunately, the proposed 2-hour pre-notice remains problematic and may still result in the creation of excess emissions in order to comply with the prior notice requirements. We propose red line language to Rule 903D1E that qualifies the notice obligation to as soon as reasonably practicable, which was a suggestion made by Commissioner Gonzalez. Our proposed change to this rule is for 3 main reasons. First, operators cannot always predict when a well requires liquids unloading. Thus, even a 2-hour pre-notice requirement is not feasible, and often an immediate unloading of a well is required and is the most protective operational action to avoid a swabbing event. Second, operators will not know if a well liquid unloading event will prevent the need to swab the well until the manual unloading event is in process. In this circumstance, even a 2-hour pre-notice will not be achievable. Third, by requiring notice via a Form 42, all operators, including in some instances contractors, will need to access the eForms login, which would also require cell service on location and a presumption that the COGCC eForm system is functional and not overloaded by multiple Form 42 submittals. This is concerning for operators in more remote locations where cell service may not be available, when the operator personnel authorized to submit the Form 42 may not be immediately available, and also when multiple Form 42s will be submitted at the same time, which is a high likelihood under this proposed rule. Furthermore, it's important to acknowledge that APCD and the COGCC will receive key information regarding the number, frequency, and best management practices for well liquids unloading events as a result of the proposed Form 42 notification, and also through GP11 maintenance emissions permitting, greenhouse gas reporting, and APCD Reg 7 emissions inventory reporting, and potentially even the new Reg 7 air emissions monitoring requirements. This reporting is coupled with the fact that several operators have extended an invitation to the Commission to attend scheduled manual well liquids unloading events to obtain more information about this operation, which is the ultimate goal of this notice requirement. We believe that these field visits, in addition to the significant information that the COGCC and CDPHE will receive through the proposed Form 42 notifications and CDPHE reporting, will comport to the intent of this rule and the information that the Commission and Division are seeking. Looks like we may have lost our screen share, but we do have a red line for you to Rule 903D1. We will certainly email it to you if we can't bring the screen share up here. It does include our request to add or well plugging to acknowledge that venting and flaring will occur when a well is plugged, and both activities are covered by the same provision of AQCC Reg 7. These changes will ensure that the regulation of well liquids unloading and well plugging is reasonable and necessary under the Act. And we'll be sure to email our slides to Ms. Larson following our closing remarks. So with that, I will turn it over to Mark Matthews.
Good morning. I would like to echo those who preceded me by thanking the director and the COGCC staff for their thoughtful revisions to the 900 series. I'll be addressing two issues of the changes made in the last draft to Draft Rule 903D6 and the Draft Rule 915 addressing concentrations in sampling for soil and groundwater. First, the industry group appreciates the changes made by the COGCC to 903D6. In particular, we thank the Commission and COGCC staff for recognizing just how unworkable it would be to make retroactive the new requirements that pits within 2,000 feet of a building unit or a DOA emit less than 2 tons per year. And we also appreciate that the Commission and COGCC staff saw the wisdom in accepting from the rule's strict emission limits certain facilities used for recycling or reusing produced water. These changes likely averted the shutdown of many of these kinds of facilities on the West Slope. That said, we do want to lodge an objection to the statement in the draft, statement and basis and purpose for 903B that public health needs to be protected by setting a, quote, default rule that oil and gas emission sources, including pits, be located at least 2,000 feet from a residential building unit. As we argued strenuously in the 300 and 600 series, we don't find any support in the administrative record, including your sampling data, indicating that emissions from oil and gas operations or pits impact residents 2,000 feet away. The industry group also objects to the statement in the draft statement and basis and purpose that continuing to allow 5 tons per year of VOC emissions from pits is too great a health risk, and question whether that statement is necessary or reasonable. I'll ask Chris Colclasher to say a few words on this particular issue.
The statement of basis and purpose asserts that pit emissions may contribute to tropospheric ozone formation, but the record contains no data supporting this assertion or the choice of the 2 and 5 ton per year thresholds. EPA screening tools to assess whether an individual proposed source will cause or contribute to ozone violations are available, but were not used. Those tools would show that individual pits or other sources larger than 2 or 5 tons per year do not cause or contribute to ozone violations, as EPA uses those terms, and the record contains no analysis of their potential combined impacts on ozone. There is also no record to support the statement of basis and purpose conclusory assertion that methane emissions from pits contribute to climate change, or any estimate of how much methane they might emit. The statement that operators can reduce the flow of hydrocarbons into pits by appropriately tuning separators is simply not correct. Separately, the proposed pit rules clash with state and federal Clean Air Act regulatory programs. The Clean Air Act does not set this type of firm, one-size-fits-all emissions cap for categories of sources. Sources with emissions above various thresholds are subject to more stringent requirements, but they can be built and can have emissions above the threshold so long as they use any required emission control technologies. Individual facilities that cannot comply with applicable standards may be denied permits on a case-by-case basis, but that is very different from the proposed hard caps for an entire category of emission sources. EPA and AQCC regulations allow much larger sources of emissions to be built and operated if the owner demonstrates that the source will not cause or contribute to violations of ambient air quality standards. These demonstrations often use sophisticated air quality models that account for emission rates, control measures, background concentrations, wind patterns, terrain, and other site-specific factors. Compliance is enforced through comprehensive monitoring, record-keeping, reporting, and inspections. But the proposed rule overrides this finely tuned regulatory approach. While staff has consulted with the Air Division, and the proposed rule does not create a situation where it's impossible for operators to comply with both sets of rules, if only because a source that is never built under COGCC regulations does not violate AQCC rules. The proposal nonetheless deviates from established regulatory schemes in important ways that have not been considered. Thank you, and I turn it back over to Mark.
Thank you, Chris. I will finish by discussing Draft Rule 915. While COGCC staff made meaningful changes in the last go-round to Section 903D6, it declined to do so with respect to Draft Rule 915. We do appreciate the several footnotes that were added to Table 915 in the penultimate version of the rules. These footnotes will allow the director much needed discretion in establishing necessary alternative values for the constituents listed in the table. That said, we do have two major concerns that we believe are not currently addressed in the draft rule or the draft SBP. First, there has been no clarification as to what pathway to groundwater means in the context of Table 915. This is a critical issue in light of the stringency of the protection of groundwater soil screening levels in the table that apply if the director finds such a pathway. Now, the draft SBP states there's a presumption that EPA's RSLs will apply generally, and that EPA's groundwater soil screening levels will only apply when the director finds a pathway. But what does this mean? This is a highly technical and very important issue. As we stated during our presentation, a work group should be assembled to address as precisely as possible the criteria the director should use to determine whether a pathway to groundwater exists in site-specific circumstances. Finally, there remains a concern by industry operators that employment of such stringent standards, which are often below PQL levels and ambient background levels, will result in operators submitting a flood of exception requests to the Table 915 criteria to the director. This flood of requests could slow the pace of remediation in the state, and therefore the plugging and abandonment of wells. Moreover, leaving sites that need to be remediated open while operators wait for consideration of alternative standards could pose a considerable concern for health and the environment. To avoid this, we believe the agency will need to submit substantial resources to provide timely responses to the numerous requests it will be receiving in the near future. Thank you very much for your time this afternoon. That includes our presentation. To the extent we have not used all of our time, I wonder if we could allocate that to Western and rural local governments. Thank you.
Thank you. Thanks to the panel for their presentation this morning. Do commissioners have questions? Commissioner McGowan.
Thank you, Mr. Chair. I think could we go back to the comments about the pits and setting an overall emissions cap and how that violates the Clean Air Act, please? And I guess I see that we've set limits, but we allow a pathway for folks who are going to be releasing more than 5 tons per year if you can show certain things. So it's a cap, but it's not really. There is an opportunity for pits for more than 5 tons per year if I'm reading the new red lines appropriately. If you can show us that you're working towards some things or you meet some requirements. So how does that violate the Clean Air Act?
Yes, thank you, Commissioner McGowan. Chris Colclaser for COGA. I would say that it's a cap with some exceptions. And these exceptions are not based on the same criteria that the Clean Air Act or AQCC would use. And it takes away the opportunity to show, for example, that the facility would not cause or contribute to an ozone violation or would not, would not violate the prevention of significant deterioration standards. So while there are exceptions for some particular categories of pits, including the produced water pits that we are most concerned about, this just acts in a very different way. And the fact that there is a cap, even if it does have exceptions, I think the fact that there is a cap is very different and inconsistent with how the Clean Air Act functions.
Commissioner McGowan.
So even though we're coming about it in a different way, I guess that I need to ask staff if the commission has the authority to do so. So maybe we can talk about that later. I just would like some clarity from our legal team. Thank you, Chris. Appreciate it. Sorry, Mr. Klobuchar.
Commissioner Putnam.
Thank you, Chair Robbins. And I also had some questions for Mr. Kolklischer, starting with that same point. Given Senate Bill 181's direction to minimize emissions, isn't that going above and beyond what was already present in the Clean Air Act? And if so, I'm not sure I understand your argument that just because it goes beyond what the act says, that creates an inconsistency. I think that was the legislature's point, wasn't it?
Mr.
Thank you, Commissioner Putnam. Clearly, 181 tells you to minimize emissions. I think that can be done in ways that are consistent and fit within other regulatory structures without imposing a ban, recognizing there are exceptions for some types of facilities, but without imposing a ban. In my view, this really moots a lot of the work that is done at CDPHE in terms of receiving a permit application, reviewing the emission limit that has been proposed, assessing whether it will cause or contribute to a violation, assessing potential health impacts. This sort of brushes all that aside and simply says you cannot have a pit if it emits more than 2 or 5 tons per year in some of these circumstances. And that there's just nothing comparable in the Clean Air Act. And so I would encourage you to find ways to minimize emissions and fulfill that statutory mandate in ways that are more consistent with the existing program of CDPHE.
Mr. Kolklischer, a couple follow-ups on that, and then I've got a couple of other questions. First, isn't the Clean Air Act just create a floor on what the state can require so that it doesn't create a prescriptive path for how states are supposed to calculate those issues, but at least create a floor that could be exceeded through other actions like 181?
Certainly a state can regulate more stringently than the Clean Air Act requires, and Colorado does that. And many of the rules that you're adopting in this mission change rulemaking do that. Just to be clear, I'm not trying to argue that this is outside of the Commission's authority. What I'm saying is that it deviates from the way that sources are regulated. The Clean Air Act has been in effect since 1970, has been working on, that there are very well-developed regulations that tell agencies how to evaluate the emissions from a source, and those balance the ability of sources to develop with protection of air quality and protection of human health. And I think that you can minimize emissions while building on that existing scheme without putting in sort of a hard cap that just cuts across the lines that have been constructed in air quality regs over the last 5 decades.
And on that point, this is limited just to pits and not to the other elements that AQCC and APCD regulate. So how large a change is this really, given the relatively narrow scope of the pit regulations?
Certainly appreciate that it's a narrow scope. I do think it sets a precedent of regulating in different ways. And again, I think it just sort of renders irrelevant much of the work that the Air Commission or the Air Division would do on a permit application.
Within that narrow scope though, right?
At this point.
So just to change the subject just a little bit, but I think staying to your comments on pits, I wanted to make sure I understood your argument about methane. I think you suggested 2 points. One, that there wasn't a lot of information in the record quantifying the degree to which methane may exist in the pits, but I also thought I heard you say that there was no record connecting methane to global warming. Do I have you wrong on that?
I was not attempting to say that. I was trying to say that the record does not evaluate how much methane these pits might emit or whether it's a significant concern.
And then similarly on the connection with emissions of VOCs and the creation of tropospheric ozone, is your point just that we don't have quantification on the degree to which it's created, or that the VOCs would contribute to tropospheric ozone creation? VOCs
are clearly an ozone precursor. So I'm not trying to argue that VOC does not contribute to ozone. I'm trying to say the other point, that the record does not assess the quantity, nor does the record look at the location or how this ozone, how these precursors might interact in the atmosphere, because ozone is not directly emitted from sources. It's formed in the atmosphere by a photochemical reaction of VOC and NOx, and so it is not linear by any respect. You're not able to simply look at a quantity of VOC emissions and say that will result in 1 part per billion or 2 parts per billion of ozone. But as a general rule, 5 tons per year is not enough to have any measurable or predictable impact on ozone. The state looks at emissions in the range of, I believe the man-made VOC emissions across the Denver ozone non-attainment area are something like 250 tons per day. And that contributes to about a quarter of the region's ambient ozone concentrations. So I think the point is just 5 tons per year is a minuscule contribution to ambient ozone concentrations.
And I think recognizing that these are small parts of a bigger puzzle isn't part of what the legislature directed in Senate Bill 181 to address the cumulative effect of all of those small sources of emissions. So I'm not sure how that saves your interpretation under 181. Don't we still need to look at those small ones and minimize?
You need to look at them, but I think looking at them includes calculating how many of these sources there are, adding up what their potential emissions could be, which is absent from the record, and assessing whether their total impacts across the source category would have an impact on ozone. It's one thing to minimize emissions, but if the basis for adopting this regulation is because it will improve ozone levels, there should be some factual record to assess whether the emissions of these precursors cause or contribute to ambient ozone concentrations, and that is not in the record.
And I guess I'm still confused. If the direction from the statute is to minimize emissions, and the regulations are designed to implement that statute, why do we have to go through all those extra steps for purposes of this rulemaking?
I think you need to do that because the justification in the statement of basis and purpose is that this regulation, and specifically the restrictions in the 9-county ozone non-attainment area, are intended as an ozone mitigation measure. And we do not know that, I mean, there is no record to show that this will have any measurable or modeled impact on ozone concentrations.
But if you reduce VOC precursor emissions, it will have a beneficial effect on ozone, even if it's not quantified, correct?
Potentially. It depends on the amount of the ozone precursor emissions and their location and how they interact in the atmosphere.
And is it your suggestion that we always have to calculate that to support any regulation? I mean, we don't do that at AQCC.
I'm not saying always or any. I'm saying that the record here is non-existent on their potential ozone impact. And this is a very small source of emissions. So I do not think that that modeling, if performed, would show any impact on ozone. What we're really trying to point out is that the record just does not have the information to support the conclusion that it is drawn.
So last question, and I know you spent quality time at the Air Pollution Control Division thinking through these issues. Do we ever do ozone modeling for relatively small individual sources?
There is a screening tool called the MERPS, the Modeled Emission Rate of Precursor, that can be used for an individual source. It is normally not done for an individual source, and the division's modeling guidance says that it is normally not required. But this rule does not apply to an individual source. I would say, again, the point that we are making is that if the commission wants to act on the basis that this rule will have ozone benefits or is needed to prevent ozone violations, that there should be some information in the record about the level of VOC emissions that are affected by this regulation, and that information is simply absent.
And I guess just one last question. Where is that in 181?
Again, we recognize that 181 says to minimize emissions. Our point is that in the statement of basis and purpose, the cited justification for this restriction is ozone. The cited justification is not simply to minimize emissions. And if you're going to adopt a statement of basis that says you are imposing this regulation in order to improve ozone or protect against ozone concentrations, that there should be some record supporting that justification.
Okay, I think I understand your argument. Thank you, Mr. Koklischer.
Thank you, Commissioner.
Thank you, Commissioner Putnam. Commissioner Messner.
Thank you, Mr. Chair, and thank you, Commissioner Putnam. I found that interesting line of questioning, and thank you, Mr. Koklischer, for answering those questions and help me better understand. I asked this question earlier from this particular group, but I think at least what I heard in that last interaction was that there's some agreement that Senate Bill 181 does require this commission to look at ways to reduce emissions. And I think that this particular topic that's being discussed here, is in an attempt to look at emissions and make some adjustments in a narrow scope to be able to reduce emissions. I mean, another approach here is to take a pretty broad swath, like a previous party just testified, around reducing oil and gas operations in general, a certain percentage. I'm more in favor of a surgical approach than a broad approach, but in lieu of trying to reduce emissions in a surgical approach and continuing to hear pushback from industry, on that approach, I guess my question is, would you rather see a bigger, broader approach to reduce emissions, or would you rather continue to look at surgical approaches to reducing emissions like this particular one is attempting to do?
Yeah, thank you for that question, Commissioner Messner. I would say that a surgical approach should be guided by information. And what we have here is a proposed threshold of 2 or 5 tons per year that is narrower than an outright ban on the industry, but does not seem to be guided by information or facts to justify the selection of those emission thresholds. And with respect to the previous comments about reducing industry by 25% per year, again, I would just reiterate my prior testimony. There is no statutory basis for that.
Okay, thank you.
Other questions for this panel? All right, thank you, panel, for your presentation. We will Zoom you away. It is 10:34. We had a 10:30 break, so I would propose we take our morning break and return at 10:50.
And we said 10:50. I need to let you know that the chair has been unavoidably detained. And so we need to have somebody run the meeting in his absence. My suggestion is Commissioner Messner, given his experience on commissions in the past. And so I just would like to check in with you and make sure that's okay with all of you if Commissioner Messner serves as the interim chair while Commissioner Robbins is detained. Could you give me a thumbs up? Okay, does that work for everybody? Thanks very much. Commissioner Messner, take it away.
Okay, thank you. And Ms. Larson, I'll certainly need help with the lineup here as I don't have that in front of me right now. But who do we have next?
Yes, thank you, Mr. Vice Chair. Next up, we have Be the Change and Phil Doe. Mr. Doe has 5 minutes for his response statement. So we will get him into the meeting. One moment.
Okay, thank you.
Okay, thank you. I had a hard time getting in here. It's my Luddite background doesn't work most of the time. I sent this to you this morning. I'll read it. We have serious problems with the COGC's recent 900 series, particularly the BC analysis, the cost-benefit analysis dated September 18th, 2020. First off, your declaration of legislative purpose is wrong. The statement upon which the COGC sees every rulemaking is apparently to be tied, and we quote, "This section sets forth the Commission's powers and requires the Commission to consider certain factors when exercising its authority under the Act. The section now requires the Commission to regulate oil and gas operations in a reasonable manner to protect and minimize adverse impacts to the public health, et cetera, et cetera, et cetera." Well, first of all, protect and minimize, that's illiterate. You can't both protect and minimize at the same adverse impacts at the same time. So compare your statement, declaring the legislative purpose, with what the law actually says. And this is the letter of the law. Your purpose now is to regulate the development and production of the natural resources of oil and gas in the state in a manner that protects the public. This is a simple declarative sentence. There are no qualifiers or modifiers. This state is simply instructed as a matter of law to regulate the oil and gas development and production so as to protect the people and the environment. The concept is unadorned, impossible to misinterpret. By adding modifiers such as reasonable and minimize, the impossible is made possible. Thus, we get the interpretation in 902A and B of the draft rules. See October 26th morning YouTube discussion by Mimi Larson at roughly 51 minutes, 20 seconds to 40 seconds. I'm paraphrasing, but essentially what Ms. Larson claims that under this rule, if another state or federal agency approves air, land, or water pollution, that pollution is not really pollution within the framework of the COGC's authority under 181, since that pollution has been authorized and that it is therefore lawful or reasonable. She says, for example, that if the APCD approves a pollution permit, that permission is lawful, and the COGC's responsibility under the law to protect the people and the environment is satisfied, as is the APCD's. This is an absurd conclusion that basically repeals the clear intent of SB 181. In all cases, the state must determine through careful examination of both the individual and cumulative impacts whether an oil and gas proposal of any kind is protective of the public and the environment. It is state law and cannot be voided or shunted off with claims of it ain't none of it me. The state has an obligation to make this law work, not muddy it up with qualifiers such as reasonable and minimize that make the law flaccid and unworkable. Even though those terms can be found elsewhere in the law, it might be helpful to consider that in all cases, the protection of the people and the environment is always reasonable because it is the clear intent of the law. It would be unreasonable to draft rules, as you've done here, that do not protect the people, but put off that responsibility with some misbegotten legalism. The loose use of minimize in these rules is another example. You seem to think that protect and minimize are synonyms. They are not. Clearly, you can minimize without protecting, particularly if one goes from the individual impact analysis to the cumulative. What looks minimal in the individual case may become monstrous if multiplied or repeated hundreds of thousands of times. Pollution and well pad permits come to mind. Here's an example from the November 3 rule. Whenever the director has reasonable cause to determine that an operator is impacting or threatening to impact public health and safety, the director may require the operator to take action to avoid, minimize, or mitigate the potential impacts. We've highlighted in red here what we think leads to inconclusive enforcement. First of all, the director must, not may, require the operator to take action. It is much more powerful to simply add that he must do this to protect the public and the environment. The term minimize and mitigate are temporizing. There are actions that, quite frankly, may not protect the public or the environment in all cases. We add that monetary calculations in the BC analysis are sophomoric at best. They only analyze the cost of the industry and conclude that those costs are not equal to the benefits. This analysis may expose a bias toward the interests of the industry and a bias that dominates this rulemaking. If you think we exaggerate, count how much language is devoted to the rights of the people in this rulemaking exercise. We do not need to remind you that the law was written for their protection, not the industries. I'll just go back here to say that, you know, you actually get yourself into trouble with the APA when costs exceed the benefits.
Mr. Doe, excuse me, you have exceeded your time.
Okay, I'm done. Thank you very much. I hope that gives you a moment to think about what you're doing here.
Thank you, Mr. Doe. Commissioners, do you have any questions for Mr. Doe?
Of course not.
Seeing none, thank you for your testimony, Mr. Doe.
Sure.
Ms. Larson, if you could bring up the next party.
Yes, of course. Next up, we have Environmental Defense Fund, ALGC, Gunnison County, and City of Aurora.
Ms. Paranos, will you be the only one? Oh, I see we got a Mr. Grossman here.
I have Dan Grossman joining me as well. Yes, thank you, Commissioner. And I think as long as Dan is here, he's on. Perfect. Elizabeth Pranos here on behalf of Environmental Defense Fund, the affiliated local government coalition, and the City of Aurora. We wish to extend our sincerest gratitude to Director Murphy and to her staff for all of the great work on Rules 903 and 904. We support the latest staff drafts and urge the Commission to adopt them. In particular, we support the recent addition of the prefatory language in Rule 903, and I'm going to have Dan speak now on that point. And then after Mr. Grossman, I have a few points to talk about with respect to the timing of the Form 4 submissions. So with that, I'll turn it over to Dan Grossman.
Mr. Grossman, I think you need to unmute.
Let's see. Let me text him.
Is it *6 on the phone to unmute? Is that right?
There he is.
Thank you. Thank you, Ms. Paranos. Thank you, Commissioner Messner, members of the commission. I apologize, I'm not participating by video today, but just audio. My name is Dan Grossman. I'm the Rocky Mountain Regional Director of Environmental Defense Fund. I would like to echo my gratitude to Ms. Murphy and to the members of the commission for addressing venting and flaring in the 900 series. The latest proposal, staff proposal that you see includes a lot of negotiated language that EDF and some of our partners in industry had lots of conversations about and came to an agreement about. And most important from EDF's perspective is the prefatory language in 903, which basically sets forth the policy going forward for COGCC, and that is the regulatory presumption that venting and flaring is not permitted. This is important not just because it sets the tone for the rest of the changes that the Commission is considering, but it's also important because, as I said, it creates that regulatory presumption that venting and flaring is pernicious from a waste perspective and from an environmental perspective, and that it's going to be presumed to be improper and inappropriate unless it's specifically permitted within the other provisions that the Commission is considering. We think that this is important, not only for that regulatory certainty that I just mentioned, but also to send a signal to other states and other jurisdictions that are considering flaring regulation that a clear and unambiguous prescription of venting and flaring, except as expressly permitted, is the starting point and the bar that other jurisdictions should follow as they look to Colorado for leadership on this issue. Once again, I want to thank the commission as well as my friends in industry who helped negotiate this language. And I'll turn it back over to Ms. Pranos.
Thank you so much, Mr. Grossman. So I attempt to just share my screen. Are you able to see that, commissioners?
We can see the 903D3 slide.
Perfect. That's fantastic. That's what I wanted you to look at. So as you know, staff provided some options for the commission's consideration with respect to the timing of submittals of Form 4s. Those are submittals that existing wells who are currently flaring or venting pursuant to sundry notices would be able to submit pursuant to Rule 903 to receive approval from the director for up to 1 more year of flaring or venting. As you see in this red line language here, we propose that all Form 4s be submitted no later than January 15th, 2021. And this is because we believe this reflects our understanding of the submittal date timeframe that we've been considering since the beginning of this rulemaking process. So as you know, we initially proposed a 6-month timeframe in which operators would be allowed to flare from an existing well due to failure to connect to a gathering line. And that proposal from EDF was for a one-time only submittal. In working with staff and other stakeholders, eventually staff proposed a one-time only request for permission to flare for up to 1 year. Again, we always understood that 1 year clock to begin at the time that the operator submits the Form 4, and that Form 4 would need to be submitted no later than the effective date of the rules, which is January 15th, 2021. Operators have been on notice that the COGCC flaring and venting rules were going to change since last November. That's the date that the white paper came out. And then of course, in January, the initial straw dog rule of 903 that did propose changes to venting and flaring rules came out. So operators have already had 1 year to start making plans to either connect their existing wells to gathering infrastructure or provide for alternative methods to capture rather than waste gas. And again, we believe that an additional year is significant, is more than enough time for operators to essentially halt the waste of natural gas. And that is all I have for today, but we are available for questions if any commissioners have any.
Thank you for that testimony. Commissioners, Mr. Putnam or Commissioner Putnam.
Thank you, Chair Mester. And I had a couple questions for either Ms. Pranos or Mr. Grossman. And I'll just lay them both out because they're somewhat related, and I think particularly related to something that Mr. Grossman was discussing. I think the first is, how would you benchmark the proposed 903 venting and flaring rules against other states and proposals that are out there? New Mexico is obviously in the middle of a process. Texas took a small reporting step, I think, in the last couple of days. And the second related question is, assuming we move ahead with these, how can we help other states, use this, and, what would be most helpful in, providing that good model that could be spread?
Mr. Grossman?
Thank you, Commissioner Metzner. Mr. Putnam, great question. The draft that you all are considering now would be among the strongest in the nation, with perhaps the exception of Alaska, as far as flaring regulation goes. As you know, and as you stated, Texas is looking at improving its regulation of flaring, although it's unclear what exactly the Railroad Commission is going to actually do other than the reporting that you mentioned, the improvements in reporting. The state of New Mexico is currently considering and has a proposal out that Ms. Pranos is very familiar with that addresses venting and flaring in the state of New Mexico as well. It's in the proposal stage at this point that the Oil Conservation Division is considering. The other jurisdiction that comes to mind is North Dakota, which the Commission may be familiar with. Back in 2014, and it has been amended a couple of times since then. They implemented a statewide field order which requires operators to comply with a statewide gas capture goal and purports to allow production limits on operators that fail to meet those gas capture goals. What we've seen in North Dakota, unfortunately, is that regime has been ineffective, mainly because the Industrial Commission has been reluctant to actually enforce the production limits power that it has. So we've seen, I wouldn't say unabated, but we've seen continuing issues with flaring in North Dakota. So it's a long-winded answer, Mr. Putnam, but I do think that it's that this rule, if adopted by the Commission, will send a message to all the states that are considering improvements and set a bar at a good high level that will allow us to address this issue going forward. And then, I'm sorry, the last thing I'll say is that depending on the outcome of the election, obviously, there may be some more movement and interest by the Bureau of Land Management to take up again the issue of flaring on federal and tribal lands across the country. And again, having a good, strong signal from Colorado will help us ensure that rule is as strong as it can be.
Mr. Putnam or Commissioner Putnam?
Thank you, Chair Messner, and thank you, Mr. Grossman. Following up on one part of your response related to the state of Alaska, what does the state of Alaska do that we're not doing in these proposed rules?
Well, Alaska is somewhat unique insofar as it simply just requires either the capture or the reinjection of associated gas. And I think that that's unique to Alaska because of the ability to do that reinjection that simply doesn't exist at a similar scale here in Colorado. But the language of the Alaska rule is quite strong, and the way that it's enforced is quite good. But again, I believe it's because of the ready availability of reinjection of gas. And I don't know if Ms. Paranos has anything else to add about Alaska.
Thank Dan. I mean, Mr. Grossman summarized it well. I think the only thing I would add is simply that the Alaska rule doesn't necessarily have the same requirements for completion activities. So what the Commission has proposed here with respect to limiting venting and flaring during both the initial flowback phase and the subsequent flowback phase is stronger than what Alaska has. But with respect to the routine flaring, Alaska has had on the books a clear prohibition on routine flaring from producing wells. And as Mr. Grossman mentioned, that is because of the availability of injection as an alternative for those operators that aren't able to put the gas into a pipeline.
Thank you both.
Other commissioner comments, questions? Seeing none, thank you for your testimony. Ms. Larson, who's next?
So next up, we have La Plata, San Miguel, and Pitkin counties. We will move in Mr. Iatridis.
Mr. Iatridis, you can start whenever you're ready.
Thank you, Mr. Chair. Good morning, commissioners. La Plata and San Miguel applaud the improvements to Rule 904. And while we've made several requests on a number of different rules, I'd like to focus my attention here on just Rule 904. We support the changes, and I'd like to encourage you to go a little bit further. In particular, Rule 904C indicates that the commissioners do want to gather broadly information about a variety of issues, and that's reflected across all the changes in 904. It's an excellent step forward. We support it. We ask you to keep it. It's important to have a mechanism for gathering information from both existing and new facilities, and we applaud you. Our concern is that there's no regular collection of information with 904C. It's an ad hoc basis, and it can be narrowly applied or it can be broadly applied. So As I had said earlier, we encourage you to have statewide reporting on an annual basis. The benefits of that are to everybody, the commission, the communities, the neighbors, and to industry. You will have more information and you'll better understand and can manage the cumulative impacts. You will be able to identify and reduce risks with more comprehensive information. The reporting will create patterns over time, and that will help identify new opportunities to save on natural resources and to minimize impacts, and it will identify cost savings for industry. It will also help industry with compliance. So the more we know, the better everything can occur. Every thing we all want to do can happen. And much of this can happen without the commission or staff having to get involved. Just by creating a database and making it publicly available, independently, people can respond to it and take action. So it's not just all on your shoulders. So we really encourage you to do that. A quantitative database will help reduce staff resources. And I can appreciate that staff is coming out of this with a lot of homework and assignments, and they want to try to be as efficient as possible. If you make the database quantitative, it can be populated automatically, it can be analyzed quantitatively, and hopefully it will reveal things that will improve the overall process of the regulation of the industry. You can put in gallons, tons per year, miles, number of complaints, a whole bunch of things. You can add mapping capabilities so people can understand where they are. And we strongly encourage you to take it a bit further. Thank you for all your hard work and for your dedication to improving our community. Thank you.
Thank you, Mr. Iotrides, for the always thoughtful testimony. Commissioners, are there questions or comments? Commissioner McGowan.
Thank you, Mr. Chair. Thank you, Mr. Iotrides, for coming this morning. I think I'm not quite understanding what change you would make to 904C. 904C right now is kind of the ad hoc ability for the commission to, as issues come up, have discussions, look individually at issues, and it sounds to me you're talking more like wanting to create some sort of annual assessment or database that gets reviewed, which I guess in my mind is more related to, oh, sorry, my computer's stuck now. 904A and kind of the report that we're going to work on with the director around various cumulative impacts. So maybe I'm not quite sure exactly what it is that you're asking for.
My apologies. Sorry, Mr. Chair. My apologies for not being clear enough. It's a good question. 904C, I think you can just leave it as it is. It's good. 904A is good. I guess my suggestion is to create an annual operator reporting requirement. And that could be, excuse me, that's my timer to stop talking. But since we're on questions, it no longer applies. I guess it could be a 904D, and it would be an independent reporting requirement. To me, I read 904A as the commission having its report. And I think to feed information to the commission and to the public, you could create a 904D, and it would just be an annual operator report. Annual reports are routine in environmental regulatory programs and in non-environmental regulatory programs. And the collection and transmission of the information into a central source would be of great benefit. And I think you could do that through it would be a new provision in the regulations. And I've hesitated to propose where it would get created, but that is the ask, is to create a new information source for the commission and the staff.
Commissioner McGowan.
Thank you, Mr. Chair. So I feel like we're trying to use CIDR as the information source and the place where operators are submitting their data. Would this be something different than CIDR?
My understanding of CIDR is that the topics in CIDR are narrower than what we are proposing because it's cumulative impacts. So to broaden it, whether it could be added into CIDR and expanded, then yes, that could be a vehicle. I don't know the details of CIDR very well to be able to say one way or the other. And I think Commissioner Putnam is your CIDR expert here, perhaps, and maybe he can.
I think we're all learning what CIDR might be or not be. So,
Yes.
so
Commissioner McGowan.
So I guess to me, CIDR, if everybody is putting their information into CIDR, we're going to individually be able to add up and look at cumulative impacts. And so I guess I'm really struggling to make a connection to what you think is missing and how we would do it, use it differently from trying to create the central repository, which is CIDR. I'm not trying to argue with you. I'm just trying to figure out how it might be different or how it might be useful versus us trying to create something that's central that that we can use, that CDPHE can also use. And wouldn't everybody putting their data into CIDR help us see the picture of cumulative impacts?
I think it would. And again, if it's the CIDR cover, gallons used, and identify where the water went. Does it talk about miles traveled on local roads, the number of complaints received on noise, light, odor, etc.? If it is, then maybe my request is based on ignorance of what CIDR is. And if it is, my apologies. Again, my limited understanding of CIDR is that it's just covering a narrower group of topics. So if you wanted to put it in there, great, I would just expand it. To be more
I understand.
in line with,
thank you. I understand better.
More in line with the cumulative impacts discussion as opposed to more of the air and more narrow issues.
Thank you.
Commissioner Putnam.
Thank you, Mr. Chair, and thank you, Mr. Iotrides. I guess one question that I had, recognizing that this is a worthwhile objective and something I think we're all interested in doing, but not knowing exactly how all that works from IT and database and other sort of perspective. A question is, does this need to be in a rule, knowing that the rule may have a kind of longer existence than any particular database structure, or should it be more of a policy direction, either in the statement of basis and purpose or beyond that? I'm just struggling to figure out how to craft a rule with that precision without the kind of record and kind of background on exactly how that would be structured at this point.
Mr. Iotrides.
An excellent question. It has to be pragmatic and cost effective and informative, and it should have the bang for the buck that's being applied to it. And I'm no IT expert either. Perhaps, and just thinking off the top of my head, you could have a general requirement for all facilities, not just those who are applying for new permits, to submit information to CIDR as adjusted from time to time, so that it is parallel or analogous to 904C. 904C authorizes for these ad hoc meetings. Perhaps a 904D can authorize annual reports, to be very specific, and it can cover topics, and then as adjusted from time to time, then later you can add more meat on the bones in through guidance and through policy, and says here is the form, and then the form can evolve over time by identifying different categories of information and how you would like it to be reported so that it's useful. And so maybe you can do a blend of what you're talking about, and maybe this is a work group project, to get stakeholders together, because you don't want to just make work. You would like to be efficient and create something useful. So perhaps in the rule, have something more general to be detailed later.
Thank you.
Okay. Other commissioner questions? Seeing none, thank you, Mr. Iotrides. And Ms. Larson, if we could bring on the next panel.
Yes, excuse me. Next up, we have TEP Rocky Mountain and Mr. Michael Jewell.
Good
Mr.
morning.
Jewell, whenever you're ready.
Chair Messer, thank you very much. Thank you again for your time. Michael Jewell on behalf of Terra Energy Partners and TEP Rocky Mountain LLC. If you take nothing else from my closing remarks, please take Terra's intense gratitude for yet another collaborative task achieving our shared goal of preserving the beautiful natural environment in the state of Colorado. It is no small indication you've already heard support from not only industry, but also citizen and environmental groups, and we only reflect the same here. With Rule 903(d)(6, you've recognized a highly beneficial win-win trade-off, nearly 100% recycled clean water purified from hydrocarbons and VOCs. And again, the way Terra does this is through its millions of dollars that it invested in 2 centralized water treatment facilities that remove virtually all hydrocarbons and VOCs from produced water prior to use and recycling. This investment has been a success, removing nearly all traces of hydrocarbons from 42 million barrels over the past 4 years. That's 99.9% of all recycled or produced water in completions activities by the Piceance Basin leader. But with that said, Terra wants to be clear that 903(d)(6 is not per se a Western Slope exception, although we thank you that you are sensitive to divergent operational needs. This rule is available to anyone who wants to have recycling programs or has them currently. And further still, the West Slope should not be held to unscientific speculation as far as emissions are concerned. Terra is the vanguard of environmental stewardship on the West Slope through this recycling program, so we're very glad that this beneficial program will be allowed to continue. We also agree, somewhat in reverse of the citizens group, that the proposed recycling language is a little vague, but in a manner that invites opportunities for an operator guidance, which we do hereby request. Terra believes the Commission wants to partner with operators committed to good water stewardship practices, so we anticipate we will continue to trailblaze a path to clarity on this discrete manner. Lastly, we support the comments made by Ms. Wozniacki in the industry group regarding liquids unloading. A reporting requirement is far more appropriate than a notification requirement. As Terra indicated in our opening statement, the additional Form 42 requirement will create an unnecessary burden for not only operators, but more importantly, it will create unnecessary redundancies for the COGCC staff. So thank you again for your time. And if we could, we'd like to reserve any remaining time we have to WRLG. Thank you.
Thank you, Mr. Jewell. Commissioner, questions or comments? Seeing none, thank you for the testimony. And Ms. Larson, if you could bring on the next panel.
Yes, the next party to present is Weld Citizens and Ms. Matsumoto. So one moment. Mr. Vice Chair, we're not able to find Ms. Matsumoto, so we can move on. We'll keep looking for her, but we can move on to Mr. Stephen Lewis Prescott and United Water and South Beat.
Sounds good. Mr. Prescott, I see that you're in the room. If you want to unmute yourself.
Thank you, Commissioner Messner. I was indeed talking to myself. Commissioners, thank you for your work on this rulemaking. I think you've done a great job. I also want to thank you for the clarity that you've provided the districts with respect to plugging and abandonment and closure of wells that are in the pathway of future surface development and surface use. I think staff's comments were also helpful, pointing to the statement of basis and purpose and the fact that there is nothing in the rules that would be interpreted or intended to preclude future surface use when it comes to plugging and abandonment. I just want to bring to your attention the importance of this issue in a real time. Literally yesterday, United was communicated with by an operator who is intending to plug and abandon 2 wells on the exact land on which a reservoir will be constructed in 2 years. And this is the exact situation before you and that you've provided guidance on. And I just want to walk through it to essentially confirm that my advice to the client is correct under your rules, being that when they go to the operator who has consulted pursuant to the rule correctly, when they go back to the operator and say, hey, this is where a water reservoir is going to be built, compliance with the standard, I should say, plugging requirements is not going to be adequate in the situation. You need to actually plug and abandon this well below the base, a safe distance below the base where the water reservoir will be constructed. And that is what's necessary to ensure that surface use in the future is not precluded. And the operator may respond in one of 2 ways. They may say, yes, you're right, that's what we have to do under the rules. They may say, no, under the rules, all we need to do is plug this 50 feet to the surface and do like we do everywhere else, and we're good. And my question to you in that situation is, what does the district do? If the operator is not going to comply with the rule that they can't preclude surface use, is it proper for the districts to now come to the commission? This hasn't happened yet. It's hypothetical because I don't know how the operator will respond, but say they do not plug in a way that will allow the water reservoir to be constructed. Is the proper response to come to the commission, and will the commission take action to ensure plugging is done in a way that doesn't preclude water reservoir construction? The end.
Is that the conclusion of your comments?
Yes, it is. Thank you.
All right. Thank you, Mr. Prescott. While I acknowledge that you posed a question, I think staff will have the opportunity to answer that question either in closing, or if another commissioner would like to ask that question of staff, there may be an opportunity now if they're comfortable answering that question to answer it now. Okay. Any other questions from commissioners? With that, thank you, Mr. Prescott. And Ms. Larson, who do we have next?
Next up, we have Western Rural Local Government Coalition, and then with them are Garfield County, Moffat County, Rio Blanco, Mesa, Logan, Morgan, Yuma, and Los Animas counties. We will bring them in, and just a note, they have a total of 16 minutes and 28 seconds that time that they've received from other parties. So we will get them in and let them start their presentation.
And Mr. Robbins, I see that you're here. I'm happy to give you the con if you would like it.
Thank you, Commissioner Messner. I appreciate that, and apologize for a slight diversion here at the House. But I'm here for now. I may need to take another break, and if so, I'll call on you again, but I appreciate that. Good to see you, Mr. Jacobs. And I see that the rest of your group is attending. let us know when you're ready to go.
Yes, with me this morning is Mr. Kirby Wynn, Oil and Gas Liaison for Garfield County. He'll be providing our closing remarks. We do have the issue of the requested clarification or supplementation of the record. We'd be happy to address that after Mr. Wynn's closing remarks, if that would be appropriate.
That's fine. Thank you.
Very good. Mr. Wynn.
Thank you, Mr. Jacobs, and thank you, Commission. I think just right off the bat, we definitely, as a group, and this is 3 different groups that we're representing today, the Western Rural Local Governments, plus Mesa, Moffett, Rio, and Logan, Morgan, and Yuma counties, as well as Los Animas. What we want to emphasize more than anything this morning is our appreciation for the engagement and the receptivity to our recommendations on these rules and the many revisions that we've seen that address those issues. So I'll go into a few specifics. On Rule 904, we thank the Commission and the staff for the revisions to Rule 904B as in boy regarding cumulative impact studies that may be required as a condition of approving an OGDP and the nexus of such a study that might be requested and the OGDP or location being considered for approval. We think that you're getting it much more in the realm that it ought to be, and so we appreciate that. WRLG and the counties also appreciate and endorse the new provision in 904C for establishing an informational hearing docket. We think that'll provide great benefit to y'all as well as stakeholders around Colorado. Going on to Rule 903, to discuss some of the venting and flaring and pit emissions topics. WRLG and the counties, we share the concerns expressed by COGA, API, Westlope COGA, and CARIS as well. In that we believe any prohibitions on venting and flaring must accommodate practical operational realities and allow for compliance by operators. As such, guidance is warranted and should be prioritized for early development as these 900 series will go into effect. Just get that guidance out just as quickly as possible. The SBP references to allowing an operator to not to capture natural gas, to tank emissions and control of emissions, and the general intention for operators to flare in certain search situations, all we believe need further clarification and reconciliation. I know you heard about that in much more detail by people more expert than me earlier today. Just a quick note on well liquids unloading. While that's not inherently a local government issue, we do believe the draft language in Rule 903 D1 Big E requiring no less than a 2-hour advance notification of a liquids unloading event is a solution that seems to be lacking a problem to be solved. Liquids unloading is such a basic and common procedure in our areas that it's hard to understand how the Commission is going to be making good use of its time, even attempting to look at rapid fire and short fuse notifications for these commonplace events. For sure, the Commission has a need to receive information on the unloading activity at some point, but can anyone honestly believe the Commission is going to ever, more than perhaps very rarely, actually engage the operator in a substantive manner that reshapes the outcome within a 2-hour turnaround time? Doesn't seem likely, and it seems that would be a rare occurrence, and if true, the rule, as staff often states during all these proceedings, the rule should address the majority of outcomes and not the rarest of outcomes for such a minimally impactful operational practice such as this. Going on to the 2 and 5 ton per year VOC emission limit for new pits in Rule 903 D6. We think that could prove problematic to meet. You've heard plenty about that today already. We see both numbers as fairly low emission levels as compared to so many other permitted on and off pad emission limits, and continue to question the need for such low limits. However, we do support, and I absolutely, representing all of our jurisdictions, we just cannot overstate our appreciation for the flexibility afforded to operators of pits used for recycling and reuse of produced water in 903 D6A, little Romanet 3, I guess you would say it. Moving on to Rule 915 and Table 915.1, we also thank staff for revisions to many of the values in Table 915-1 that were of concern to WRLG and the counties because they could force larger volumes of E&P waste into local landfills. However, we do understand that a few of the constituents and their cleanup concentrations in the latest revised Table 915-1 do remain a concern, and that guidance with respect to application of cleanup concentrations is still warranted, even with the benefit of the footnotes, which we appreciate, that are in Table 915-1, and we do see those as helpful. We support and request prompt development of such guidance on the use of the table and the benefits for the benefit of operators, and also my emphasis is for the indirect benefit of local governments and local landfills that could see impacts depending on how the rules are implemented. Going on to our final topic is Rule 909F and G, the netting and fencing of new pits and use of multi-well pits. We really appreciate the revisions to Rule 909F, excluding existing pits from the blanket requirement to install CPW approved exclusion devices. And we support the Commission's reliance on its current practice and authority to require netting and or fencing of existing pits on a case-by-case basis. We think that covers it. We also support the ability, again, of the Commission under new Rule 909G4 to require a multi-well pit to be netted, covered, fenced, or closed based on the evidence of risk to public health, safety, welfare, environment, and wildlife. And with that, again, we absolutely appreciate the engagement on this rule series and appreciate how you all have been responsive to what you've been hearing about. And with that, we'll open up to questions and then potentially that topic about admission of a new exhibit into the record, if you'd like.
Why don't we open it up to questions from Commission on your closing, and then we can do a short discussion or hear from you on the other topic. So, Commissioners, questions for this panel? All right, well, I'm not seeing questions. I think perhaps a lot of that is because we've reached some consensus that seems to be workable for your communities, and so while also being protective. So I appreciate that. Mr. Jacobs, did you want to address the one outstanding topic about the report, or Mr.
Yes.
Mr. Wynn?
Thank you, Mr. Chair. I'd be happy to address that. As you know, and as the hearing officer deferred to you for action by the full commission, conservation groups and Mr. Delahanty on their behalf used a table of data on salinity of produced water from an article in their closing statement slides for this series. And that was objectionable to us. It was misleading. And the article, but was clearly limited by its title to the Wattenberg field. This drew a criticism by Mr. Wynn at the time, and reasonable and understandable response to the use of that, and our having first seen it, and everyone having first seen it during closing statements. We thought it limited to the Wattenberg field, as indicated by the title of the article. Then after closings, Mr. Delahanty submitted this lengthy article and asked to clarify the record, when in effect he's seeking to supplement the record. All parties were out of time at that point. There were no other written submissions contemplated or allowed by the amended case management and pre-hearing orders in this docket. So it's largely a procedural objection. Moreover, it's not necessary. The point of Mr. Delahanty's use of that table was to indicate that there's a range of salinity of produced water in Colorado. This commission has a mountain of data on produced water, its salinity and every other characteristic of it, among other data, and can access those data at any time to understand the range and how that relates to the regulation of produced water pits, which was the issue. The article in question has not been reviewed by WRLG, the counties, Los Animas, or any of the parties or staff, to our knowledge. It's an old article of very limited, if any, benefit to this commission in this record. And it's simply bad practice to allow big articles full of information that nobody's seen at the 11th hour. And we would urge this commission to not allow its introduction for that reason alone. It's not super consequential. Again, the range of salinity is well known to the commission staff. Mr. Duranlo even spoke to it. He understands the range of salinity and how it's quite low TDS in some areas like Los Animas and the Northeast counties, Washington, Yuma, and others, and other areas. So it's really a procedural objection. We renew the objection. We think it best practice procedurally to not allow large dumps of information at the 11th hour in these proceedings, and to encourage parties to get their information on the table in a timely fashion and consistent with the case management order and the hearing officer's direction. And that's really all there is to it.
Okay, thank you, Mr. Jacobs. Do any commissioners have questions for Mr. Jacobs on this discrete point? Okay, thank you for that. We will now move this panel off. And commissioners, I would beg your indulgence, but now that we've given that side the opportunity to have a couple of minute oral argument, I think it sort of makes sense for us to hear from Mr. Delahunty on this issue so that we've got our notes in the same place. And then, you know, a couple minutes, and then we can just like hold that to the side. And when we start deliberation, we can take up the issue. Are you guys comfortable with that? AAG Davenport, are you comfortable with that, actually?
Yes, that's fine.
Ms. Larson, if you could bring Mr. Delahunty to the panel for a brief minute or two's oral argument from his perspective. Mr. Delahunty, I'm sorry to put you on the spot, but I think you got this. Can you provide your perspective on this for us?
Sure, happily, yeah, and thank you for the opportunity to respond. A couple of points. I think, you know, first, I would just emphasize that the table that we presented in our rebuttal statement was really in response to some of the claims that were made by WRLG and others about basically the appropriateness or the need for beneficial use in the state. So just as, I guess, by way of explanation, the reason that this was brought up later in those proceedings was in order to respond to what those parties were saying. And, you know, the reason that we think the study as a whole could be included, or should be included in the record, is really just to provide some context for the table that was presented. You know, I don't think we disagree that there is ample data about produced water in the state, and I think that the table that we presented nicely summarizes what that range is, and it, you know, it does matter in terms of understanding basically when a default rule versus an exception should apply for things like fencing and netting. So all of that is to say, we think that the table is really what's most salient. We think it's helpful, and really the rest of the study just provides the context to show that the table basically says what we said it says, which is the produced water levels for the state as a whole, as opposed to just the Wattenberg field, which is what WRLG wrongly asserted. So this is just a point of clarification for the table that was already brought in response to what those parties were arguing.
Thank you, Mr. Delahunty. Do commissioners have questions? All right, seeing no questions, thanks again. I appreciate your perspective there. We will table this issue and take it up at the beginning or end of deliberations. Ms. Larson, who is our next panel?
Our next panel is the Small Operators Society. We will bring Mr. Moore in and Mr. Wackerman if he is available as well.
Good morning. It'll just be me today and not Mr. Moore. So if y'all can hear me, I'll get going.
We can hear you.
All right. Good morning. Almost good afternoon, commissioners. Eric Wackerland closing on behalf of SOS today. I will start as I did last week during party testimony by thanking Director Murphy and the staff for continuously engaging with our group in a meaningful manner to solve some of the key issues identified in our pre-hearing statements. Director Murphy and staff's engagement and willingness to listen to our concerns and seek a mutual resolution has resulted in rules that are tough but fair, capable of implementation, and will promote the goals of SB 181. To those ends, SOS wants to make clear to the Commission that we support staff's proposed changes to 5 specific 900 series rules and respectfully request the Commission adopt these proposals. First, as indicated last week, we support the removal of the requirement to net and fence existing pits under 909F and instead require netting and fencing only as needed on a case-by-case basis. This is the right approach. Preserves the directors and CPW's discretion to require netting and fencing where circumstances warrant, and avoids an outcome that would have presented an existential threat to many of our members. We note that it is critical the same approach is followed when the Commission takes up this issue in 1202. And we also note that SOS presented testimony showing a lack of record evidence regarding bird and other wildlife mortality that was specific to Colorado that would justify a broad netting and fencing requirement. We also provided evidence showing widespread wildlife benefits owing to many freshwater pits, and don't believe many of the statements in the 909F statement of basis and purpose, for example, quote, that wildlife mortality, especially bird mortality in the administrative record, are accurate or supported by that record. Second, we support the staff's new language in 909G, allowing certain multi-well pits located in specific counties to operate under a multi-well permit for more than 3 years. We appreciate the opportunity to bring evergreen natural resources before the Commission and the ability for them to testify about the significant benefits of the produced water CBM pits in the Raton Basin. Third, we support the subsequent annual sampling and stable water off-ramp under 909J2B and staff's change to 909J6 to allow sampling of produced water from the same formation. Fourth, we support the overall approach on venting and flaring and particularly appreciate staff's inclusion of the Third Creek situation in that language. And last but not least, on 903D6, like Kirby said, we very, very much appreciate the changes. We think the approach that staff landed on reflects both the discussions we had with staff and the lengthy deliberations on this topic last week, and appropriately balances wise water use, particularly on the west slope with the goal to reduce emissions. We also generally agree that a different approach to emission issues between the Front Range ozone non-attainment area and the rest of the state is often warranted and is here. I will say, however, that we remain concerned, and we heard about this morning, that COGCC is imposing a standard that effectively says if you're above this, you have to shut down or can't build. This approach is contrary to how the Clean Air Act works to regulate emission sources. I'm not aware of any Clean Air Act program that sets a standard like the 2 or 5 ton issue here and says if you can't get emissions below this standard, you can't construct or operate. Instead, what air rules do is set standards that are protective and then require sources above that standards to control their emissions, or in the context of SB 181 to further minimize those emissions. This is generally done through an air permit. So in the example of the 2 or 5 ton per year threshold we have here, an air rule would say if you are above this, you need to make sure that you have the right controls, even the best controls. And we are going to ensure you do this through a permit. I don't think that rule, if it was an air rule, would say, like this rule does, if you're above this, you just can't build. So places in Reg 7 and the oil and gas program there, like the storage tank control program, provide good examples of this language and framework. So in concluding here, we appreciate and urge the Commission to keep this new proposal intact. It is vastly improved and we worked really hard on it. But we ask that the Commission consider clarifying that the thresholds are not strict ceilings above which operators are precluded from constructing pits. Rather, those thresholds say that if estimated emissions are above those thresholds, the pits will get additional scrutiny and potential additional controls may be required. With that very minor change, which we don't think affects materially the rule, we think it would be in a good spot and consistent with SB 181. So that concludes my testimony today. I'd be happy to answer any questions, and thank you for your time.
Thank you, Mr. Wackerlin. Do commissioners have questions? Commissioner Najapa? No, okay. All right, we're seeing no questions. Thank you for your group clients' continued participation. I'm glad to hear the theme echoed that a lot of your issues were sorted through. I'm happy to sort of see that from lots of different stakeholders from various perspectives. And I agree, it echoes a tremendous amount of work by our stakeholders and particularly by our staff. Ms. Larson, who's next?
Mr. Chair, next we have Western Resource Advocates and Ms. Walker.
Good morning, Ms. Walker.
Good morning. Joro Walker for Western Resource Advocates. I'm going to join many other stakeholders in first thanking the commission, the director, the staff, and stakeholders for their hard work and commitment to the mission change mandate, all of which is evident in the current version of the 900 series. So WRA focused its participation on ensuring that the Commission has the information it needs to minimize emissions of greenhouse gases and address the adverse impact of oil and gas operations on climate. So having this information is of further importance because it gives members of the public the information they need to participate in a meaningful way in decisions evaluating and addressing cumulative greenhouse gas emissions. We fully support the changes to Rule 904 because we believe that the rule carries out these crucial objectives. WRA has also proposed that the way for the Commission to safeguard public health and the environment from cumulative greenhouse gas emissions and to protect climate is to use its unique regulatory authority and expertise to do its part to meet Colorado's emission reduction goals. Doing this and similar work may well be one of the most important challenges of our lifetimes. The new Rule 904 will certainly foster these efforts, and we look forward to doing our part in the new COGCC processes to help Colorado reach its emission reduction objectives. Thank you.
Thank you, Ms. Walker. Do commissioners have questions? Very good. I'm not seeing questions. We thank Western Resource Advocates for its continued participation with us. Ms. Larson.
Yes, Mr. Chair. Next up is Rocky Mountain Low-Level Radioactive Waste Compact. Ms. Green is their counsel. We're not seeing Ms. Green in the meeting. If she is there and could raise her hand, we will Zoom her in. Otherwise, if she's not, that would conclude the party responses for today.
Do you want to, or I'll just do this, but if there's any party that was on our list that we did not get to and you desire to speak, could you raise your hand at this point? There were a couple that we did not see, including the Rocky Mountain Low-Level Radioactive Waste Compact. Give a few seconds for raising of hands or not. I don't know if I can see hands being raised, Ms. Larson, but if you see any, let me know.
I will, and at this point, there are no hands being raised.
All righty. With that, we are actually 5 minutes ahead of time, but that's fine. We are due for a 1-hour lunch break, And then we would come back and initiate commissioner deliberations on the 900 series. So if everybody's comfortable with that, I would suggest that we come back at 1 p.m. this afternoon, and we will start in commissioner deliberations at that time. Thank all of our participants for your closings this morning and for your participation, and go have a nice lunch, and we will see you at 1.